appeal in the matter of MOC by his litigation for MG and set free state religion.
Yes, good morning, Miss Weston.
My lords, my lady, good morning. I appear for the appellant in this matter, assisted by Mr. Rutledge, who sits behind me, and Mr. Percy, who also sits behind me.
Yes.
And I'm opposed by Ms. Claimant, for the Secretary of State, who is supported by Ms. Richardson, who also sits behind her.
Yes, now, could we just do a bit of housekeeping? As you may have been told, there's going to be a fire alarm in this block. If you weren't told, I'll tell you now. And that's meant to be at 1 o'clock. If it happens before 1 o'clock, it is a fire alarm, but the test will be at 1 o'clock, so we'll finish at 5 to 1 to allow everybody to get clear. On other matters, we know that you have an application to amend and to file further evidence and so forth.
Yes.
We propose to approach that by taking everything in for the purposes of your argument, and then we'll decide when we've heard everything what actually evidence we will be considering, so we'll decide those matters as part of the overall consideration. So we needn't spend time on ancillary applications. We'll also continue the order that was made recently, and I'm just saying it because we're being recorded, for the anonymity of your client and his family members.
My lord, I'm grateful.
Right. Are there any other preliminaries that you or Ms. Clements would like to raise before we get on with the substance?
My lord, yes, I just wanted to check that the court had everything we think it should have, if I may.
Yes.
So there should be the core bundle,
Yes.
the supplementary bundle,
Yes.
2 volumes of authorities, 2 additional cases,
Yes.
and my learned friend has put together a small clip of further materials, and we have inserted, indeed, Section 4 of the Mental Capacity Act, which hadn't made it into the main bundle. It seems to us that it's appropriate that the court should have these for completeness, although there's no dispute between us as to the...
Thank you to everybody for the care that's gone into to putting the papers together. We've got all of that. Can I also give you just a hint that we're aware that there's an interesting point to do with status.
Yes.
And that status is obviously a building block.
Yes.
Towards any conclusion. But in common with many other courts who've considered this sort of point, I think we would like to focus principally on questions of justification. And we'll need to hear from you on status, but we don't want to spend the whole day arguing the interesting point about whether an incapacitous person does or doesn't have status. We're perfectly content, to the extent that you think it appropriate for you, as it were, to make an assumption in your own favour and move to the substantive aspect of the matter. But you'll obviously take your own course. But we're not, we signal to you, going to spend the whole half of a day thinking about whether or not incapacity of itself amounts to another status.
My lord, I'm grateful for that indication. It does mean that I will be taking a very different course to the one that I proposed.
Well, I'm not suggesting that you should miss out anything, but it's just that you might, in a sense, in your opening presentation, go a bit faster over that aspect of it. We'll see what Miss Clement says in response, and then we'll give it such attention as it seems to deserve. But for the moment,
yes,
in our thinking, that the balance tends in that direction.
My lord, I take that point, and I would simply observe at this stage that in our skeleton argument we had, on the issue of disposal, put the potential outcome that this matter would have to be remitted for further findings in respect of the justification exercise, particularly as this is a case when the test adopted by Upper Tribunal judge below was the standard manifested without reasonable foundation test, and not the more nuanced, fact-sensitive
All right.
test.
Well, you'll take that in when you come to argue the justification.
I'm grateful.
Should we have that extra clip?
Yes.
Matter of fact, have these been submitted electronically as well?
Well, they haven't, but I can arrange for that to be done if that's...
No, if it's here, they're here, but I just wanted to know whether I had them already.
No.
So I would like to start, if I may, by directing the court's attention to the very complex condition of the appellant in this case. And we find that summarised in the supplementary bundle at supplementary bundle pages 45 and 47. Now, plainly, I don't seek to reduce this appellant to the constellation of very profound difficulties that he has, but I simply draw the court's attention to the...
It's the very severest form of disabilities of all kinds.
Quite
We
so.
understand that. I mean, I think so far as the facts are concerned, I think we have those under our belts.
I'm grateful. I would simply say that the most complete list of difficulties is that we find at 45 and 47, because at various places in the bundle there's a summary of those conditions, but for completeness, that's the best description we say. So it's not in dispute here that the appellant had been awarded the highest care and mobility component, and indeed the whole statutory framework surrounding the rule, which the court will be familiar both from the documents themselves, from the provisions themselves, but also from the approach in Mathieson, where those provisions were quite comprehensively set out. I wasn't intending to take the court through that statutory framework.
In practical terms, what's arisen here is that your client's, I'll call it a guardian, neutrally, has received a demand for repayment of some £2,000 and been given a small penalty. That has led to litigation about this important point. But in practical terms, the situation that now exists is that the Disability Living Allowance is still due, but is only paid in respect of the mobility element. And so, although it doesn't affect, of course, our interpretation of the situation, I'm just anxious to keep one eye, if not both, upon the situation of your client.
Yes.
So what is represented by the dispute in this case is the Secretary of State's demand for repayment and an associated penalty.
It's not just that, we would say, it's the loss of that part of the income for the purposes of meeting the appellant's needs.
Exactly, that it's asserted on your behalf.
Yes.
That money was due, paid, and appropriately spent while he was in hospital.
Yes.
And now you're being asked to, as it were, unspend it and give it back.
Yes, but we wouldn't say yes. But we would say it's not just about that accrued, let us call it a debt, but also about the loss, the positive loss of income under that component of the DLA. So
Sorry, what loss of income? If he was paid it, there was no loss of income.
Yes.
There would only be a loss of income if you had to pay it back.
Yes, but that's right, my lady. But
Is there some other loss of income that we're talking about?
the circumstances in which his entitlement to DLA is suspended isn't limited to that period of the accrued debt. It's ongoing.
It's the ongoing suspension.
Yes.
Thank you.
Because I understand it, that component of DLA is not required to be spent on any particular item.
That's right.
So it's basically just a sum of money given as income
Yes.
to the beneficiary of it to spend as they wish. Is that right?
That's right, and
Right.
so was observed by Lord Wilson in the
Yeah.
months.
Now, presumably, some, perhaps most, perhaps not all, of that income would normally be spent on a person's day-to-day needs, like what? Food? Things like that?
Well, it wouldn't cover food.
Well, that's what I'm trying to get a feel from you.
Yes.
What is it intended to cover? If you're in the community,
Yes.
what are you supposed to be? I know you don't have to spend it on anything in particular, but what is it intended to be for?
So it would be for things like the very frequent laundry that was required, all the additional expenses. It doesn't have to be spent, but my lord has talked in normal terms, what would it be spent on? And so in circumstances where the person is living with with a particular carer in the community, there are a range of additional expenses associated with getting the person out into the community, meeting their needs for that could be ointments or laundry or particular syrup of figs, whatever the particular expenses were associated with facilitating their life in the community, which could include material support, or it could include the time and spent on providing the particular service. It's to cover a range of tailored provision to support that person in the community.
Right. In the community, as you say, in the
Yes.
community. Now, so do you accept that when they're in a hospital, at least some of those costs will not therefore have to be incurred because the hospital is supposed to be providing at least some of those elements?
In theory, yes, but then there are different expenses and care needs which arise in the context of a person who's in hospital. So, for instance, a good example is the facilitation of communication needs. So an individual who is providing day-to-day care wouldn't have to spend a lot of time explaining to other people and overseeing care being provided by another person to make sure that, in this case, that the non-verbal communication signs being given by that person weren't misinterpreted.
But why is that costing anything? Isn't that just...
Because then you have to get to the hospital, you have to spend that time in the hospital, and you have to be either at the hospital or with the professionals or going to see the professionals. It's not cost free, it's a different sort of need, but it continues in the context of somebody who's in hospital.
But I mean, people visit their relatives in hospital all the time. They don't expect to be paid by the state to do that.
No, and I wouldn't describe the use of the care component in the context of somebody in the hospital as paying the person visiting. This is a person who had been ordered by the court, and I will take the court to the provisions, to fulfil the functions of a personal welfare deputy. And that's quite and I'll come to these provisions, this is quite a onerous duty. And perhaps I might assist the court best rather than responding on the hoof if I take the court to those provisions.
Could we just go back, because I haven't caught up with what your answer meant a moment ago about losing the income.
Yes.
Are you suggesting that the dispute about the hospitalisation rule has any ongoing significance after the period of hospitalisation?
Yes, it does.
And what is that?
Because if the appellant is right and the provision's discriminatory and there is no duplication or there is no effective duplication infringement here, then for as long as the personal welfare deputy is providing the service that she provides, and
Yes, I understand. So this is I don't mean this pejoratively, but this is, as it were, a Trojan horse for saying that it doesn't just apply to the period in hospital, but it continues indefinitely. Is that right? That for so long as she's the deputy, the rule, any rule which abates the DLA when he's not at home will be discriminatory. So I had understood when reading this that
Yes.
this was just about the hospitalisation period, and that in the end the consequence of our decision, one way or another, forgetting its wider context,
was finite.
was either be that you had to pay
Yes.
back £2,500 or not.
Yes.
Assuming it may be that there might be some discussion between you, but assuming that remained a live issue in the context that we've now got to. But actually, you're arguing this on the basis that if you win on this, then you're going to go on to the period in the nursing home, are you? So that's discriminatory because she's got to be there 24/7 in order to perform her
That would be
task as a guardian.
that would be an issue of fact. That would turn on the factual circumstances engaged at the time of the.
The principle would be the same.
Yes, either it's discriminatory.
So basically, your argument has got to be, although we're talking about the hospitalisation thing, and this all blew up because you were asked to give some money back, that actually any time somebody in this position is not at home when entitled to DLA, and you would say they have a guardian, that it would be discriminatory not to pay the full DLA.
I would put it this way, if I may, my lord, that if it's right that a person who lacks capacity, who is severely disabled, is additionally vulnerable because of that capacity, of lack of capacity, and requires a person to meet needs resulting from that, and those needs are not being met by the hospital, yes, it would be discriminatory.
Right, so the answer to my question
the
is, in
context.
fact, yes, isn't it? I mean, you've gone around the houses, but I now think I've understood what your case is in a sense about in terms of its breadth and scope.
If my lord will forgive me, can I just ask a supplementary question to that? Does it follow, therefore, that this case is not just about the hospitalisation rule? Suppose, never mind the nursing home,
Yes.
we may have to come back to the significance of that, but if your client was simply in the community, I assume you would say that there are certain costs associated with being a personal welfare deputy which should be met by the state. Is that right?
No, I don't say that.
You don't
no,
say
no,
that.
no.
Okay, so while he's in the nursing home, is that treated as being in hospital? That was my understanding from reading the papers.
There's a similar suspensive rule, yes.
The hospitalisation rule does apply, so it's basically applied for the last 5 years.
Well, it's a different rule, but it has the same effect.
Yeah, so that's the rule you're attacking in these proceedings. Is that
Yes.
right? Yeah. All right. So,
Well, on the facts, I'm obviously constrained by what the scope of the appeal was before the Upper Tribunal below,
yes, you are.
and that was all about the hospitalisation rule.
Yes. Yeah,
There
we're
was
certainly
no.
not going to hear anything
Yes,
else.
no, exactly.
That
So
we can be clear about.
yes. So that's the scope of my appeal.
Good. Right. Okay. And just before I leave that, therefore, as I see it, although there are the facts of this particular case which have generated this legal issue, the actual legal issue which we have to determine is whether or not the relevant rule, which is contained in legislation, albeit it's secondary legislation, whether that rule is or is not compatible with the Human Rights Act, and therefore lawful or unlawful.
Yes.
You have to attack the rule as a generality, because if the rule is valid, then of course the Secretary of State was perfectly entitled to, indeed obliged to apply the rule.
I do not attack the rule in generality.
Well, if you don't, then I don't know what this case is about.
Well,
It seems to me you have to attack the rule.
I don't say that it's not permissible to have, as indeed the court did not say in Mathieson, that it's not permissible to have a rule, a general rule. The question is whether it's
There'd be an
discriminatory.
exception to it.
Exactly.
No, I understand that, but what I'm saying is it can't be an exception which is just made on the facts of your client's case.
No, it's made on the basis of a status, and the status is a person who is severely disabled and lacks capacity.
And if we agreed with you, then the consequence would be, presumably, that the government would have to enact a new rule, just as they did after Mathieson, to reflect the age point.
Yes.
That's what you're asking for is that we should, in effect, order the government to change the legislation.
What I would never tread on the constitutional toes.
No, we can do that. There's nothing wrong with doing that. I just want to be clear that that is the effect.
I'm not
argument.
suggesting that this court should prescribe what the answer to the change to the rule to the regulation might
I understand that, but they couldn't maintain the rule as it currently is. They would have to change the rule, not just on the facts of this case, but as a matter of legislative rulemaking.
Yes.
Yeah.
In respect of the class that I've identified,
exactly.
the cohort that I've identified.
There's nothing improper about that. That's what we do. And if a rule is unlawful under Section 6 of the Human Rights Act, then it's invalid. And we say so.
Yes, and we say it would have been open to the first-tier tribunal if they would have been with the appellant to disapply the regulation.
Not just open, it would have been their duty to say
Yes,
so.
quite. So then I'd like to take the court, if I may, to the principles concerning appointment of a personal welfare deputy, because they are material, we say, and they should have been treated as material by the court below.
Yes.
So I would be grateful if the court would turn up volume 1 of the authorities. Where we see at tab 2 extracts of the Mental Capacity Act. Now the court actually does have the order appointing
I think all of this is referred to in the judgment, isn't it? What the appointment was, when it was, what it was for, what it wasn't for. All of that's in the order, which is referred to in the judgments, are they not?
It is, my lord.
Yes,
but
so we've got that.
Yes, but what the judgment doesn't do, in my respectful submission, it's worthwhile having a look at the order itself.
All right.
What the judgment doesn't do is look at the wider duties and responsibilities of a person appointed a personal welfare deputy, and in my respectful submission, get a handle on why that was material to the to the status.
Take us to the order. Is that tab 3 in the supplemental bundle?
It's at
Page 8.
yes, page 8.
And it's all listed on page 9.
That's right.
And it's basically a standard form order for the appointment of a welfare deputy.
Yes, it replicates the statutory provisions,
Yes.
sets them out there. But it's important in my respectful submission that the order itself sets out in quite a lot of detail what can and cannot be done with the power of being appointed a deputy. And if one goes back to look at the power to appoint a deputy, which is in tab 2 of the authorities bundle, you see the power itself is at section 16. And we see in section 19 the limits on appointing a deputy in some consequential matters.
What's the particular point that you want us to get out of the legislation?
That particularly at 19.6, the point of a personal welfare deputy is that they are to be treated as P's agent in relation to anything done or decided by him within the scope of his appointment and in accordance with this part.
Yes.
That's important in my respectful submission because it's part of the statutory framework which requires the personal welfare deputy to give agency to the person who is who lacks capacity. And if one turns up the Mental Capacity Act Code of Practice, which is at the back of back of volume 2, we can see at page 148 that the limited circumstances in which it will be appropriate to make such an order, as opposed to the court taking a decision itself. In particular, if we have a look at paragraph 8.38 on 148, I don't know if the court just wants to read through 838 and 839 first paragraph.
Thank you.
Sorry? 8.38, paragraph 8.38, page 148. Bundle pagination.
Yes. Now, we can go around this quite a lot,
Yes.
but essentially let's just contemplate this in a sense of reality. This gentleman came upon his disability some years. I'm remembering 2006. No, sorry. The time when he became severely disabled as a result of illness was
1996, I think.
96. Sorry, thank you. I'm sorry to have misplaced the date. And he, very sensibly, his relative was appointed as a court of protection deputy.
Yes, in
For
2010.
welfare matters, and for all I know, maybe also for property and affairs matters, but that doesn't matter. But welfare matters, and became his appointee, and so on and so forth. But one has to reflect on the fact that this extraordinary act of love and commitment
Yes.
on the part of his relative had been carrying on for 14 years before anybody appointed her to be a deputy. that the degree of assistance, invaluable assistance that she provides, is being provided because of their relationship and because she has voluntarily chosen to become his carer during the periods with which we're concerned. It's got nothing at all to do with the fact that she is the deputy. And the role of a deputy, speaking from the perspective of a court of protection practitioner, is not to be there 24/7 to provide for care needs, to facilitate the daily actions of life. It's an entirely different matter. And if other deputies who do their job conscientiously were to hear the submission that they're meant to be there 24/7 in order to make sure that other professionals are doing their jobs, they would be aghast. That's not what a deputy is for. Now, I put my cards on the table so that you shouldn't be taken by surprise. How can it be otherwise? This is not a process of providing for constant presence, however valuable the constant presence undoubtedly might be.
We wouldn't premise the significance of the appointment of a personal welfare deputy on presence or the need for constant presence. That's why we were careful to seek to situate the relevance of capacity within the severe disabilities, rather than the sort of freestanding concept. The point here that we're seeking to make about the significance of appointing a personal welfare deputy is that once appointed, there are a range of statutory duties which come with that. For instance, the requirement to act in accordance with Section 1, the principles of the Act, and Section 4, acting in the best interest. All those duties are on a statutory basis. An annual report has to be made to the OPG that these principles have been complied with. And in a case such as this, that may mean, and has meant, constant presence as part of the equation.
I'm sorry,
but
it is unreal that the relative in this case is not going to hospital and spending large parts of every day there because she's the deputy. She'd do it if she wasn't, and she did it before she was. And one can only feel admiration for that. But as a point of principle, it seems to me that the fact that she is very sensibly his deputy has absolutely nothing to do with the practical arrangements. And besides which, the contention that this is required of a deputy is again unreal.
It's we would say it's not factually correct to say that she would have done it. She was doing it before, and she was doing it afterwards. After the MG was appointed in 2010, there were issues relating to the deterioration in his condition and increased needs, which necessitated her to take on a role of advocating for...
Yes, it gave her the legal right to do what she wanted to do in his interests.
And the responsibility, the legal responsibility.
Yeah,
But that has nothing to do with whether he was in hospital or not. Presumably those obligations, which you say exist, and let me accept that for the sake of the argument, but those existed at all times from 2010.
Yes, they did.
So what's it got to do with the hospitalisation rule and whether that's unlawful or not?
Because part of her role and function as personal welfare deputy was to ensure in MOC's best interests, for instance, that those people who are now charged with his care in the context of the hospital properly understood his means of communication, that the care that was delivered to him was personalised because she was able to understand and communicate his wishes and feelings and all those aspects of the function of the personal welfare deputy, which are quite subtle, and the court will be familiar with. And
She's doing it as a relative. She's not doing it as a deputy.
my respectful submission
I mean,
that
there are many deputies who are not, who are in certain contexts are institutional deputies.
that we say that the legal obligations that go with appointment as a personal welfare deputy are of significance.
Well, they are, but it
they
might be
weigh-
a social
they-
worker. In the financial sense, it'll probably be an accountant or something of that sort. But I mean, the concept of a deputy just doesn't lend itself to extrapolation as being that you're there to check on professionals, making sure they're doing things correctly for the sake of your relative.
Well, it's
Sorry, I'm
expressly
repeating myself now, but I mean, whatever is said in the Code of Practice, the reality of a deputy's responsibilities are at a much more high level.
My lord, these are the authorisations given to this particular deputy in respect of this severely disabled person include not just where he should live and with whom he should live, but decisions on day-to-day care, including diet and dress, consenting to medical or dental examination and treatment on his behalf, making arrangements for the provision of care services, whether he should take part in particular leisure or social activities, and, importantly, complaints about his care or treatment. Those were all, in my respectful submission, onerous responsibilities in the context of a severely disabled person. I will accept that there will be persons who are not so severely disabled, who nevertheless lack capacity, who won't need that degree of assiduous attention and supervision that that's necessary in this case.
No, but every person who's as severely disabled as this gentleman is will need all that.
Suppose that your client didn't have the great good fortune to have such a loving and caring relative to look after him. Suppose he was an only child. He would still need that care, and he would still need to have a deputy appointed. And let's suppose that the court appointed as a deputy a person who was amply well qualified, but was maybe financially astute, or a social worker. Now that person would not be going to the hospital to talk to the doctors and nurses about how best to interpret communications. They would be astute to make sure that nothing untoward happened in terms of his care. And if they thought that the doctors and nurses weren't doing their job, or that the standards were slipping, they would be in a position to complain about it. But that's a different thing.
My lady, with respect, this is a set of circumstances which, on the facts of this case,
the facts sorry to interrupt you, but the facts of this case are merely a vehicle for a point of law that we are having to decide.
Indeed.
And if you are right about status, which we're assuming for the present purposes of this debate, that somebody who is in your client's position and has a deputy has an appropriate status, then the law must apply across the board to all people in that situation, because you're asking for, as my Lord Justice Singh has pointed out, you're saying that the government should have made an exception for all people within that class, not just your client, but all people within that class. So it's no answer, with respect, to say, but on the facts of this case, it's particularly special.
Well, I wasn't intending to say that quite, but we say that where the law treats an individual as not competent to make decisions concerning their intimate care and treatment, bodily functions, but requires those decisions to be taken by somebody else on their behalf, it's essential that that function is carried out not at a distance, but in the knowledge of sufficient understanding of that person's wishes and feelings and particular vulnerabilities to make the care that they receive equal to what somebody who didn't lack capacity would have. It's the person that can advocate for their own needs, wishes, feelings and requirements doesn't need somebody to speak on their behalf, but it's essential that once it's been found that it is necessary that somebody speaks on their behalf, that they do so on the basis of a proper understanding, a thorough understanding, not at a distance, but at close proximity of what that person's wishes, feelings and communication, means of communication are. And it's that function that this personal welfare deputy provides. And although I take my lady's point that not everybody will have a personal welfare deputy, for those that do, that is a function which not only by law has to be carried out mindful of the principles of the Act, and I've cited in my skeleton argument a number of observations by the court about the importance of determining wishes and feelings in order to deliver personalised care. It's a much more difficult task to deliver personalised care to somebody who cannot communicate anything about their person.
So the defining characteristic that you seek to rely on, as I understand it, is a severely disabled person with a welfare deputy.
A severely disabled person that the law treats as having to have decisions made on their behalf.
And what's the difference between the two formulations?
There could be I have tried not to identify the class of person affected, the status, simply by reference to the personal welfare deputy. But I agree that that is a code.
No, I'm just trying to understand for the moment. I mean, you're laying emphasis on the existence and the responsibilities of the deputy.
Yes.
And I'm trying to see whether, as a surrogate for arguments about capacity,
yes,
whether in reality what you're saying is that severely disabled people with deputies are being discriminated against because their deputy is not able to fulfil their task because of the absence of full DLA.
That would be an appropriate cohort.
Well, I can understand you saying that because in a case I did once, the argument was that certain classes of severely disabled people could be regarded as a cohort in their own right because they were in receipt of a particular type of allowance. In that case, it was carer's allowance. And that was a proxy because it gave you an idea of the level of the disability of the particular person concerned. So from a particularly purist point of view, leave aside the capacity point,
Yes.
I can see that saying, well, if they are so severely incapacitated that they need a personal welfare deputy to make decisions for them, that delineates the level of their inability to look after themselves and make decisions for themselves. Now, that as my lord says, then raises the whole can of worms about whether or not one is using that as a proxy for capacity. But at least I can understand that as a marker. What I didn't understand as a marker was your reformulation of it with respect.
Yes. I take my lady's point, and indeed that was the approach taken by Mr. Justice Griffiths in the SH case, which is in the bundle, where he treated ESA as a proxy. So I see my lady's point. It did occur to me when formulating the argument with my learned colleagues that it might be said that there would be a perverse incentive for people to be appointed personal welfare deputies. But looking at the very narrow approach that the court takes to the circumstances in which a personal welfare deputy, that's to say, the position is in the Court of Protection, as my lord will know, that it would only be appropriate to appoint such a deputy if the court considered it inappropriate to take the decision for itself. And therefore we're in the realms only of the very severely disabled people in respect of whom there's going to be an ongoing need for.
Well, I don't want to hold up your argument on this point, but clearly there are plenty of people who have a marked disability who do not benefit from a welfare deputy because decisions are taken on their part by the court or
Yes.
something of that sort. So this road, as it were, would lead one to have to think about what the position of other people who were similarly stricken but didn't have a welfare deputy, where they'd be left. But that's not your concern.
No, indeed, it's not.
Right. Okay, so on you go. Is there anything more you want us to understand about the state responsibilities of deputies?
No, my lord, I've taken the court to the relevant parts of the framework. The cases that we refer to were not reproduced in the bundle. They were uncontentious statements, and those one can find it in our skeleton argument at tab 6, page 47, paragraphs 4.3 to 4.5.
Thank you.
That's tab 6 of the core bundle.
Yes.
So we set out alternative. Sorry, I've just actually, my lord, I've just jumped ahead. I struck through parts of my speaking note, given the court's indication, but I did want to take the court to two further documents in respect of the facts in this case. And the first is the first tier tribunal appeal document that was submitted by MG to in appealing to the first tier tribunal, and we find that in the supplementary bundle.
Is this the fact sheet?
No, my lord, it's actually page 30. Yeah, so the appeal form begins in the supplementary bundle at page 24.
Yes.
But the key part that I seek to draw the court's attention to is the section at pages 30 and 31. Now this is what MG set out in her appeal to the FTT relating to her role and function. And in particular, she sought to draw the FTT's attention to aspects of the function that she fulfills for MOC, and in particular, she points out a third of the way down that page that MOC lacks capacity, is Down syndrome, unable to communicate with anybody, unable to show pain, cannot see, cannot hear, chokes on food and medicines, is unable to stand, and is at high risk of infection at the end of the paragraph. And then I don't know if the court just wants to read through to halfway down the page.
This document is written in the present tense about a stay in hospital, but Was it in fact written after the event?
I understand so. May I just turn my back from
But
it?
I'm trying to situate it in the context of the history.
He was in hospital for 13 months, my learned junior points out, and that this is the document which...
Yes, he was still in hospital at the time
Yes.
this was written in,
Yes.
in early 70s.
I'm going to come back to refer to what's in that document when I go on to address how the scope of the Upper Tribunal Judge's findings, because that was a document that was before the Upper Tribunal Judge. In addition, it's relevant, we say, to have a look at what the first of the Tribunal's findings were. And we find those in the at 111 of the core bundle. So that's tab 13. Now, we've made the point in our written argument that the MG was unrepresented in this appeal, and what's striking, we say, is that the first-tier tribunal appeared to accept what MG was saying about the extent of her involvement. Their position was that...
Right, this is paragraph 15, is it? The two-page written submission.
Yes. And then a particular paragraph 19 to 22. And, sorry, from 17 to 22. So the tribunal accepted that MG continued to play an important part in looking after MOC.
And she also continued to exercise her duties as a deputy.
Yes. She stressed her function as decision maker. What's being said there is that that in addition to the physical care that was being provided, that there was a specific function that she had in respect of decision making and facilitating communication, which wasn't replicated by the nursing staff. And the first-tier tribunal certainly didn't. Their finding was that care and supervision were provided by the staff at the hospital as well as. But it's not, there is no sense in which the particular provision of a particular functions being carried out by MG were ones which could have been carried out by the hospital.
Earlier, in answer to a question from me, you made reference to, for example, the need to wash laundry. What's that got to do with being a deputy? I mean, if anyone's relative is in hospital, presumably they would do that. They don't expect to be paid to do that.
I gave that answer, my lord, in answer to a question about where the expenses would be if somebody was in the community. So I wasn't relying on that.
I understand that. Well, I'm afraid it's my fault. I at the moment simply still have no idea really. What I should be envisaging is the financial cost which DLA is supposed to pay for, which is on your argument, required. Is it the cost of being a deputy? Because that's not paid for if somebody's not in hospital. as I understand it.
The law provides that deputies are entitled to be reimbursed for their expenses. I think that's section 19.
Well, fine, but in other words, there's some other law which deals with that. What I'm trying to understand is why the hospitalisation rule on your submission is unlawful. Because it's somehow, I think your argument is that it's somehow having a detrimental financial impact on someone.
On the deputy's ability to fulfil their functions, that's right.
So what is it? What, can you give me some tangible cost which is incurred?
Well, the cost of travelling to and fro from the hospital, to and from, and attending at
but that would be a cost incurred if you were visiting your relative.
Yes, but it wouldn't have been it wouldn't have been incurred if he was being cared for at home.
Wouldn't it have been covered by the? If it's a necessary expense to carry out her functions as a deputy, she'd recover that anyway. It's part of her expenses as acting as a deputy. But if it was necessary for her to travel to the hospital in order to carry out her functions as a deputy, then surely she'd be able to pick up those expenses without having to rely on DLA.
Only from the resources of P. So if he doesn't have those resources, she can't recover them. Sorry, resources of the incapacitated
MOC,
person. That's what the law provides.
Do you accept
that's 19.7, I'm sorry.
19.7.
Deputy is entitled to be reimbursed out of P's properties for his reasonable expenses in discharging his functions.
Yes. Yes.
But do you accept that at least something that DLA would normally contribute towards financially is being provided by the hospital, by the National Health Service? Or do you say that there's no duplication at all?
I don't say that there is no duplication. I don't say that let me refine that. I don't say that there aren't care services and treatment being provided by the nursing staff while MOC in hospital. Plainly, I can't say that. What I do say that is that the fact of MOC being in hospital and not at home with his, in the community with his normal care setup, creates extra expenses and extra burdens, including, as MG has said, a daily attendance at the hospital, sometimes going twice a day for the purposes of meetings, and the need for her physical presence at the hospital instead of just being at her home.
Right. So instead of looking for extras, is it really put that the expenses may in some cases be different expenses?
Yes, they're different. Yes, they're different. And in this case, more onerous by the fact of MOC being in hospital.
Right, but the as it were, non-functional, the more emotional aspects of care remain the same. They might even be enhanced by unfamiliarity of his circumstances from his point of view. I'm just trying to frame the way in which you might want to put it.
So I think I gave the answer earlier as a response to my Lord Justice Singh, that part of the onerous nature of the function of the personal welfare deputy in attending at hospital is that she has to give informed consent, having regard to MOC's wishes and feelings and what she knows about him. She needs to intervene she needs to be present on occasion to intervene in decisions, because what she does is not just to advocate on his behalf as regards, and there's two choices available but also to ensure that he has access to treatments that may not be being offered to him. And she gives the example in her witness statement.
Right, and an intermediary role, in a sense, in that sense. That she's,
Yes, she's facilitating communication
yes,
from
understand.
in the context of lots of care decisions being taken by professionals, possibly different professionals coming through, as can often be the case in a nursing ward or a rehabilitation ward. So she is the sort of bulwark of consistency. It's an onerous task, one that, if to be done successfully, involves.
Yes, now can this be broken down as between the DLA and the mobility component? I mean, I'm understanding the argument that that his need to be accompanied by his family member doesn't diminish when he's in hospital. It may even rise, as I understand you to put it. And so, things like the tunnel pass and so forth. I can understand the mobility argument there.
Yes.
But how does it go further than that in pounds and pence?
Well, in the cost of her attending, so petrol has to be paid for, and
Well, that mobility, yes.
well, I may need to turn my back, but I don't think that the mobility covers the entire cost of the travel in this case, because the costs are so great. But
But you get the car by that contract, but you put the petrol in yourself.
yes, we have MG in court sitting behind me. I'm wondering if I just might turn my back for a moment. Oh, yes. Yeah, I haven't misstated the position. There's a great deal of cost involved in travel and daily attendance, and I think it's right to say that is the most the greatest.
We're not going to close the book on this, as it were, but just so we conceptualise this.
Yes.
In real world terms, petrol might be something that the DLA would go to.
Yes.
Right.
If your argument that the rule is unlawful is correct,
Yes.
then presumably the whole of the DLA would remain payable. Because you say there's unlawful discrimination going on here, therefore that rule goes, at least for the time being.
But if it's discriminatory, it does.
Exactly. If you win, the rule is unlawful, and therefore, presumably, the whole of the DLA should have been paid. But I just don't understand how that can be squared with what I think you accept, which is that there is at least some duplication, because the National Health Service is funding at least some of what would otherwise be paid for by DLA.
But my point is, that is right. I don't know whether I'm right to concede that duplication is the correct word, because different expenses are incurred by the fact of MOC being in hospital. And so, although it's right that some of the care, that was the physical bodily functions care,
Yes.
the hands-on Mathieson care,
Yes.
that was being provided at home
Yeah.
is provided by nursing staff.
Yes. And is that at least part of the rationale of DLA in the community? Do you accept that?
Yes,
Right, good. Okay, so that does seem to follow that there is some duplication.
but there's no duplication in fact, because the DLA is required for the additional expenses that are incurred in fulfilling the deputy's function, because in the circumstances of MOC being in hospital. So it's different. It's wrong to say that you don't need that part of the DLA because nursing care is being provided.
But look, I mean, there are a lot of swings and roundabouts. There are bound to be if you move somebody with complex needs from one setting to another. Now, my lord has been digging quite hard to find out what it sounds in the sense what's this really about. and we've unearthed petrol, I understand that.
Yes.
But if you were to take your instance of when he's at home, when he was at home, then obviously trips in the community are more complicated, may need more planning, may need more expense
Yes.
than they would for somebody without that particular characteristic. You don't have those in hospital. And so there's a swing and a roundabout, and you could no doubt devise others.
Yeah, well, there would be if he was going to have time away from the hospital. The situation would be the same. Depend on whether his condition would support that at the time. So there's no reason why trips out of the hospital wouldn't also.
Well, one assumes that if he's ill enough to be in hospital, then there's going to be some curtailment on his activities in the community. Yes.
My global submission is that my Lord Justice Singh was right to observe that there's no restrictions on how DLA is to be spent, and it's my instructions that the DLA is spent on facilitating and improving his life in hospital in all the ways that she can, having regard to her duties as a
Right.
personal welfare deputy.
If you're right and the cohort is the cohort that we described, then if there isn't some kind of exception made, or you're not advocating, as I understand it, for an exception to be made which is on a case-by-case basis for people in this cohort, which would involve exercise of discretion and administrative costs and so forth, means that the rule would be struck down, and that would potentially mean that people who didn't have to travel in order to deputies who didn't have to travel and incur these extra expenses would end up getting a windfall. Let's suppose the deputy happened to be living next door to the hospital and could walk there every day. Why should the state have to pay the full DLA allowance in those circumstances?
Just because one or a minority or a proportion of individuals benefit disproportionately doesn't mean that it's not discriminatory against if a significant proportion of deputies are adversely affected.
Well, you could in
I'm
response
thinking
to
of ESSEP for that.
well, if one lived in the Western Isles, and a severely disabled person had to be hospitalised in Glasgow,
Yes.
and that would, in a sense, magnify
Yes.
the point that you're making.
Well, there will be a range of circumstances.
Yes,
Um,
and this has got to apply to
and
all of them.
Yes, and it comes down to, and obviously, it wouldn't be a striking down of the rule as such. What it would be is a modification or a disapplication of the rule in this context. So either in an RR sense, which is the disability bedroom tax case where the statutory subordinate legislation provision was disapplied, or an amendment to the rules. It wouldn't be sort of striking down the whole of the rule. As
No.
such. That's not part of my case.
Well, what is the answer to this in that case? That if you have a situation where there can be a wide range of situations, the person who lives next to the hospital and the person in the Western Isles, and you're not asking for a case-by-case approach, because that would be unduly burdensome on a giant system.
Yes.
How do you go about saying that a rule which draws the line somewhere,
Yes.
they're bound to be winners and losers?
Yes.
How is that unlawful?
Because this rule is premised on the idea of duplication. That's to say that once a person goes into hospital, there are no that the care that is provided by the personal welfare deputy is replicated by the hospital. And our point is, no, it's not.
It is only in part.
It's not replicated. What happens is that there are different functions involved. different. In fact,
The state is putting its shoulder to the wheel in a different sense. And why is it not entitled to say it shouldn't have to double task? I mean, there are bound to be consequences from a hospitalisation of somebody in this condition.
because as the first tier tribunal found, MG's position was that the supervision function that she had, the sort of attention function she had, was more onerous once she'd gone into hospital, because she, rather than just delivering the care herself, she was required to make decisions and take part in.
He wasn't required to deliver the care.
No.
It may have been beneficial to him, and no doubt it was that she took on such a role. But there are plenty of relatives, whether they're deputies or not, who will not be able to do that or will not choose to do it.
Yes, but I go back to my previous point, which is all I can submit, which is that the function that she performed was not as personal welfare deputy, was onerous and was not. It was something necessary for the safe and personalised
Right,
care.
so could your argument,
be
in
provided.
the way that you put it, survive the fact that she wasn't a welfare deputy?
That sounds, in theory, that sounds like a logical potential outcome.
Well, I'm
But
sorry to press you, but just before you tell us why, does it survive or doesn't it survive the counterfactual where she hadn't been appointed welfare deputy?
Court has to consider.
I'm sorry, I'm going to ask you for a yes or a no before you tell us why. I don't know what you're telling us yet.
Yes.
It survives.
Yes. The reason is.
So, I'm going there just so it's not about being the deputy. Well, it's not necessary for your argument that she's a deputy. Is that it?
The key factor, and one has to look at what would happen in the real world, in my respectful submission, the key factor here is that the state has determined that this is a person who cannot make decisions for himself, and the state has a mechanism for ensuring the protection of a person who cannot make decisions for themselves, and the mechanism which is in play in this case is a personal welfare deputy. It could have been somebody with a lasting power of attorney, welfare attorney powers. So it's
the lack of capacity that defines the status.
It's the state having determined this is a person who can't make decisions for themselves.
But that's just saying the same thing with different language, Ms. Weston.
Well, it's because
All you're interposing is the fact that the state has made a determination that is the case. But it is the case because the state has said that it is the case, and therefore it's really the lack of capacity. They can't make decisions for themselves. Somebody else has to make the decision for them, whether it's somebody with a power of attorney, whether it's somebody who's appointed as a deputy, or whether it's the court itself.
The law recognises that a person in that position has particular vulnerability and particular steps have to be taken to protect that person.
It's a state-acknowledged lack of capacity. I understand you to be saying it's...
Yes. The reason why it's material that the state has made that determination is because the concept of capacity within the Mental Capacity Act and the European law is not about, it's very much harnessed to snapshots of decision-making capability. But as a matter of law, once a personal welfare deputy is appointed, there is no question in an appropriate case where, as here, a doctor has certified that capacity will not be recovered. In practice, that person is not treated as somebody who 5 minutes later might regain capacity. The person is treated, for the purposes of the law, as a person who is not going to recover that capacity.
Well, that's why I can see.
therefore,
Sorry to interrupt you, but
Yes.
that's why I can see why using the appointment of the deputy as a proxy for a certain state of health
yes,
provides a bright line acid test.
yes.
But in answer to my lord's question, you were resiling from that because his question was, can your argument survive the fact that if she wasn't a welfare deputy? The answer to that logically is no, it can't, because that's your defining characteristic. So you move away from that now and say, well, no, it covers every situation in which the state decides somebody lacks capacity.
The reason
well, of course,
I
you
gave-
then get temporal capacity problems.
Yes. My lady, my submissions are with respect consistent. The reason I gave that answer to my Lord Justice Jackson is because there are other circumstances in which the state recognises that a person lacks capacity and arrangements have to be made on their behalf. And they include, as the example I gave, the machinery kicking in under a lasting power of attorney. So I respectfully submit that it is material that the state has treated a person as a person lacking capacity because the domestic legal machinery recognises that some categories of person are not going to pop in and out of capacity in the way that UTJ Ward was concerned they would. And the question is then, what does the state do once they have recognised there is a person in that position? And the appointment of a raft of protective measures is what the state does. And my respectful submission is that the DLA component goes to ensuring that function, in this case, and indeed my respectful submission in other cases, that function can be properly carried out to the protection and personalisation, and importantly, to ensure equal treatment of the person who lacks capacity as compared with the person who does not lack capacity, who is in non-state. May I make some short submissions on where we say the court can find helpful law on status? I know the court's given its indication. I don't intend to spend a great deal of time on it.
Would you like to do that, as it were, in note form? So
Yes.
just to give us some your
Yes.
references.
So obviously we have the approach taken by Lord Reid in paragraph 69 to 71 of SC, which is tab 29.
Yes.
And then at tab 30,
So which paragraphs?
69 to 71.
Thank you.
And then in AB, we have Lord Lloyd Jones agreeing with, I think it was the day after the judgment in AB, Lord Lloyd Jones at paragraph 66 agreeing with the need to have an identifiable group, not simply by reason of the treatment complained of, and we have that here,
Yes.
we say.
No circularity.
Yes.
Yes, got that.
And then in law in Switzerland, it's quite helpful to have a look at what the Strasbourg court, which I think my Lord Reid did refer to in his.
Well, what's the proposition?
SC.
Before we dive
So in law, the Strasbourg court accepted that a sort of subset of other status of a particularly severe disability as opposed to a not so severe disability.
Yeah.
And the citation is tab 5, paragraph 80.
80.
80, my lord.
Thank you.
And then in the case of RP,
Yes.
which is at tab 6 and then paragraph 58. Similarly, the court accepted mental incapacity as being a material characteristic. I've already referred to the the approach of Griffiths, Jay, of treating ESA as a proxy. I mentioned it in response to my learned friend, my lady Andrews. The citation for that is tab 28, paragraph 62.
Thank you. That's SH.
Yes.
So all of these are helpful, as it were, framework.
Yes, I mean, my global submission would be that Strasbourg isn't averse to treating incapacity, and indeed...
Right, so if there was something bad going on here,
Yes.
one could devise, with some careful thought, a status
Yes.
for a gentleman in this
Yes.
predicament.
Yes, and indeed, if one looks at what Lord Reid says at paragraph 112 to 113, I'd ask the court to turn it up because I need
This is SC.
That's right.
Right.
Tab 29. It's helpful to turn it up, we say, because
Paragraph?
paragraph 112, my lord, it's 465 internal pagination. And the reason I asked the court to turn it up, because part of the reason why we say the court should, if it's with us on the status question, should remit the matter for further findings by the tribunal, is because of the qualitative difference between the approach taken by the UTJ on manifestly without reasonable foundation and the approach enjoined by Lord Reid in 112 and 113.
Right, so what part of 112 and
So-
113 are you particularly relying on?
So we can see that at the beginning of 112, he points out, by reference to law in Switzerland,
Yes.
that the disability cases attract the strict approach.
Yes.
That's to say, in the other parlance, treating the discrimination is a suspect class of discrimination.
But here the discrimination you allege is not on the ground of disability.
It's a disability-related matter. It comes under other status. Yes, it's.
But, sorry, what's the answer to my question? Are you relying on disability?
So we're relying on other status.
Right. So why are we looking at paragraph 112?
Because it's a reference to cases concerned with persons with disabilities.
Right.
It can't, just because we don't rely on the specific ground of disability doesn't mean that this isn't a case which concerns disabilities, which it does.
Your answer is in the second and third lines, isn't it? That the other status that you're relying upon here is one to foster full participation by people with disabilities.
My
So
lord, yes.
that's why you describe it as a disability-related other.
Yes, that's right, and yes. And indeed, in law in Switzerland, the court was of the view, I've taken the court to the paragraph, that that was a dual case, so it was disability and it was also other status. As a subdivision of disability, that's to say a subclass, a more refined ground than just disability itself. And then my Lord Reid gives another couple of examples in paragraph 113. We would endorse the mention of the paragraph in quotation marks at paragraph 112, but at 113, the court also looks at mentions further illustration of the link between the need for very weighty reasons and the stigmatising of particular groups in society, and cites the case of Kiutin that the same approach would also apply to a difference in treatment based on the person's mental faculties.
Who's being stigmatised in this context?
it's not that he is being stigmatised. The point is that disabled people have historically been horribly stigmatised, and the framework of the law is to bring them bring them within the scope of equal treatment, to be treated equally with people who are not. That's particularly in sharp focus in this case, because we say that there's a clear difference between somebody who can advocate for themselves in long-stay hospital and state their wishes and preferences, and somebody who can't. And it's that key difference, we say, which is in play and attracts the stricter scrutiny. At that point, I'd like, if I may, to turn up the Upper Tribunal Judge's decision in this case.
Yes.
Let me find that in the core bundle, tab 5. Now, it's right that in the case before the first tier tribunal and Upper Tribunal Judge Ward, emphasis was placed in the argument on the fact that this case, or on the submission that this case was analogous with Mathieson. And I think it's important to clarify the sense in which we say it's analogous. It's not said here that there was a comparable requirement for MG to provide hands-on physical care as there was in the case of Mathieson and Cameron's parents. What's said here is, for the reasons I've sought to articulate both in the skeleton argument, the supplementary skeleton, the various places in which the argument appears in the bundle, that there was a significant sense in which there was the duplication the same duplication argument that was available in Mathieson is available here. That's to say that the MG in this case was required to and did provide functions which were not provided by the nursing staff.
So, advocate, intermediary, and
Decision maker.
So, in other words, if one was to
Safeguarder, facilitator.
Yeah.
I hesitate, my lord, to reduce to very few words what the MG does, because it's my case that she performed a wide range of
yes,
protective
we're
functions.
analysing what it is that is relevant to our decision, and these are, if it just, I don't mean this pejoratively, as it were, but these are in a sense armchair functions. It's not necessary for her to roll up her sleeves. That aspect of it you're not pointing to. It's the use of her capacity and her responsibility on behalf of her relative.
Yes.
And those are, as it were, not physical, although no doubt.
Her evidence makes it clear, my lord, that there were aspects of physical functions that she provided.
I understand that.
Yes.
I understand that,
Yes.
but that's not what you're relying upon.
No,
You've just told us that.
That's right. That's not the key. The
Right.
key
You're relying
aspect.
on the non-physical contribution that she was making by
Yes.
her presence.
Yes, that's right. I'm grateful for my Lord's clarification of my submission.
Presumably there could there, in principle, because we're testing the rule.
Yeah.
So although it's helpful to illustrate by reference to a particular case, we can't be constrained always by coming back to the facts of this particular case, because
No.
we have to envisage the full range of facts which could arise in principle. Suppose the relative, for example, is not able to provide the hands-on care at home,
Yes.
but they still have these various armchair functions.
I really dislike heartily the...
All right,
description of
all right,
unlawful.
use some other phrase, but you get the point my lord is making,
Yes.
that something that has to be done, things like advocacy, being an intermediary, being a decision maker, right? Presumably, those are activities which could, in principle, have to be performed in the community. Is that right?
Yes, if care was being provided by another...
Precisely, exactly. Would your argument then be that the state has an obligation to pay the deputy?
Well, there wouldn't be a problem because there would be the individual would be getting DLA, and the individual that receives the DLA can spend the money in the best interests of the person. The question wouldn't arise because
So you say the DLA
exclusionary rule wouldn't apply.
Yeah, so the DLA is, you say, not simply designed to cover the cost of providing the care, the physical care, but also these ancillary functions.
It can cover anything that's facilitating the life in the community of the person. There
Yes.
are no restrictions on what it can
No, that's what I wanted. Yeah, I understand your submission there. Thank you.
So, as the court will have seen from our skeleton argument, it's my submission that the approach of the judge to the findings of fact was skewed effectively by the error of law we say he made about whether capacity could be part of the a meaningful component of the status.
Where do you want to take us to in the decision?
So, at paragraph 6, we see Miss Richards' submissions. I draw the court's attention to them because at paragraph 10, where I wish to take the court, he refers back to those submissions. And the generic evidence, so this was evidence put in by the DWP, which was not specific to this individual, but was along the lines of what would happen, is at the following pages. And then we pick up the approach to the claimant's evidence at paragraph 15. Now, the UTJ notes there that there's no care plan in evidence, and it's right, and it's fair to say that although there are numerous hospital-based documents, which I've not seen, and I've not been able to obtain a care plan as such, in the way which is envisioned in the evidence of government's witnesses. So what the court does there is to say there is no evidence that there was no care plan, with the consequence that the appointee had to step in. And in my respectful submission, if the court had properly directed himself to the concept of capacity and the obligations that placed on the personal welfare deputy, then that would not necessarily have been an answer to the question posed by the status and the alleged discrimination. it says at paragraph 16 that evidence from the appointee herself was limited. And then, in addition to brief submissions made by the appointee to the FTT and her oral evidence there, the Upper Tribunal had a document on its face uncertain provenance, and that was the fact sheet, and the court's already referred to it. I think the court's already seen it. But in my respectful submission, that is to dismiss the evidence that I took the court to in the document submitted to the first tier tribunal relating to the communication difficulties and the tasks that MG had to perform, and I did take the court to that earlier.
The judge deals with that evidence later in his judgment,
Well, in my
paragraphs
respect-
22 and 23.
In my respectful submission, he doesn't deal with it appropriately, and I'll take the court to that when I get there.
Is the nub of this at 21 onwards? Is that where?
Yes, well, yes, it's 21 onwards, and we respectfully submit that the approach taken by the judge and the way he summarises at the bottom of paragraph 22, the responsibilities of the deputy are cast in terms of taking decisions rather than direct provision of care. And my respectful submission, that's to leave out entirely the function that MG was performing, which was the one of which I've taken the court through, relating to the need to facilitate proper communication to make sure that the nursing care staff understood his non-verbal communication, were able to respond to him appropriately, and to also act as the means by which the nursing staff were attuned to his wishes and feelings and preferences as an individual, living, breathing person with his own identity.
You're moving rather a long way away from what the role of a deputy, as provided for in the order, amounts to. The authority of the deputy is for the purpose of making personal welfare decisions, quote, from the Act and from the order. And the decisions that the court authorised the deputy to make are a category of decisions.
Yes.
It's not to do with facilitating this and
But
forming that. It's making decisions about those matters,
my lord,
as the judge said.
yes, yes, but that was the point I'm making is that the deputy isn't only making decisions. The deputy is under a duty to act in accordance with section 1 and 4 of the Act. The deputy has a...
That's all about making decisions. I mean, this is not a... The Mental Capacity Act is not a general welfare environment. It's to do with a situation in which decisions have to be made, and when decisions have to be made, they must be made in the best interests. But it's a decision-making mechanism designed to do so in an enlightened way on behalf of people who can't make decisions. So I'm struggling to know at the moment what's wrong with what the judge says. It's not about the provision of care. There are many other legal considerations to do with the provision of care which exist entirely independently of a deputy.
Yes.
As I understand it, the point you're making is that the judge has downplayed the nature and extent of the involvement that the deputy in this case has had in caring for MOC.
By reason of his lack of capacity. In my respectful submission, the judge skirts over, and in my respectful submission, doesn't address key parts of the evidence that was before him relating to the additional functions that MG was performing, was carrying out by reason of his lack of capacity. And in my respectful submission, it's entirely consistent with the statutory scheme and part of the decision-making duties of the personal welfare deputy to ensure, and indeed making complaints about treatment and care is expressly one of her responsibilities. It's implicit and explicit to a degree as regards regard to and acting in accordance with the wider principles of the Act. That, and indeed, when one looks at the Code of Practice to the Mental Capacity Act, that sets out very clearly what the requirements are on a personal welfare deputy to ensure that they are facilitating the independence and autonomy of P. The costs, we say, in this case, the judge rejected the role for capacity in the context in the definition of status. He didn't make proper findings about the extent to which extra care, extra functions were being performed because of his lack of
What hasn't he
status.
addressed? What specifically has he not taken into account that you say he should have taken into account? In paragraphs 23 and 24. Because he's quoted from the form accurately about what she says she has to do. And he says that those requirements were principally those which flowed from the function of the deputy to take decisions.
Because what he has said is he's applied effectively the same approach as was factually correct in Mathieson. He says 3 lines down in the paragraph under the extract to which my lady just refers in paragraph 23. It's clear that those requirements were principally those which flowed from the function of the deputy to take decisions on the claimant's behalf, which would be far more limited than a requirement to assist in the actual provision of care. In my respectful submission, that wasn't the evidence. There was plenty of evidence that she was having to spend a lot of time in the hospital with the various professionals, and it wasn't just a question of the hands-on care physical care that was being provided, as in the case of Mathieson. Here, the task and the function she had was just as onerous, if not more onerous, than it had been at home. But the focus by the Upper Tribunal judge on hands-on care, in my respectful submission, missed the point about the significance of capacity as a meaningful part of the status, and indeed.
So it's not that he's missed out any part of the evidence as to what she did, but that he has failed to attribute to what she did the appropriate weight because of the incapacity.
We say it's not just a question of weight, my lady. That the scope of his inquiry about what was material about the services being provided was limited to the hands-on care issue, effectively. Right. It should have been looking at the wider tasks that were necessitated. So we're looking at the difference in treatment, we're looking at the case of discrimination. It's being said on behalf of MOC that he needed somebody to fulfil that function, the function that MG was fulfilling, in order to avail himself of equal treatment. So what MG was doing was putting him in the position that a capacitous person would have been in order to, who can express their own preferences, who can communicate their wishes and feelings, and can make decisions themselves. What the judge didn't do was look at the extent to which those additional functions, some of which she described in the grounds of appeal to the first tier tribunal, were material, and he just didn't. He circumscribed the scope of his inquiry.
Which ground of appeal is this under?
It's not a ground of appeal. The reason it arises as a on the issue of disposal, we say, consequent upon
Oh, so
Co-
it's not a point that you're making in terms of saying that the judge went wrong.
the court suggested that I focus on the question of justification, and my submission was, if we're right on status,
Right.
we say that there needs to be a further factual inquiry because there's not enough information for the court.
That I
And
understand.
not enough findings of fact.
Well,
That's how I put it.
That I understand. Can I just take you back to page 25
Yes.
of the bundle to see the structure of the Upper Tribunal judgment?
Yeah.
At paragraph 10, you're quite right, the bit you showed us about not being satisfied that it was a relevant status, and that's where the use of the word evanescent takes place.
Yes.
But at paragraph 11, the judge said,
Yes.
lest I be wrong, ... I prefer to proceed by considering the question of justification.
Yes, indeed.
So everything that you've now been showing us, subsequently, for example, at paragraphs 21 to 24,
Yes.
is all in the context, as I read it, of the judge addressing the question of justification.
That's right.
And in fairness to him, I think it should be pointed out, the reason why he drew the contrast with Mathieson was because that's how the case was put to him. But at the moment, I don't understand why this has got anything to do with your submission to us, that if he was wrong about status,
Yes.
that it has to be remitted for further factual findings. It doesn't, because this is all assuming that he was wrong about status.
But my respectful submission is that the judge's errors to status infected his approach to justification, and there were aspects of MG's evidence which highlighted the different functions she was required to perform in order to protect the interests of a person who lacked capacity.
But you see, if that were, I can understand that as a substantive ground of appeal, but it's not. I can understand it to be being said, well, if in the alternative you assume that status is right, he then went about looking at justification from looking at it through the wrong side of the microscope, because having assumed that your client did have a status, what he should then have been focusing on was capacity, and instead he's focusing on care, and being sort of led down a blind alley by Mathieson. But like my lord, I'm actually struggling to see why it's a ground for saying it should go back to the Upper Tribunal. Surely, if anything, it would have been a ground for challenging his decision on the basis that he applied the law wrongly.
My lady, there are two reasons why we say that that the court should look at the issue of disposal, and whether it has sufficient facts to findings of fact to make the nuanced justification exercise. The first is because we say that the findings of fact don't capture the significance, the capacity-related tasks, the significance of the capacity-related tasks carried out.
Well, the significance of the capacity-related tasks are a matter of view and opinion. Facts are what those tasks were, and we have the evidence of those tasks, and there's no actual inaccuracy in what the judge has said, as far as I can see.
Well,
Significance to be attached to it is part of the overall weighting exercise in the balance when one looks at justification through the prism of SC.
my point is that nowhere in the justification exercise do you see the court the Upper Tribunal judge factoring in to the justification exercise the importance and significance of the evidence relating to the capacity-related tasks.
Why does that
undertaken
need
by-
it to go back to the upper tribunal? That's an argument about him getting the law wrong.
Simply, but we say that there are insufficient clear findings of fact on the issue.
All right. Well, we have your submission.
I'm grateful. Sorry, my learned juniors whispered the thing.
Settled.
Yeah, we suggested the first tier tribunal in our skeleton argument. The second reason why we say there are insufficient findings of fact is because the court was required to carry out a more nuanced justification exercise than the Humphreys-based manifested without reasonable foundation test that he did apply. It's fair to say that in front of the upper tribunal there was agreement that that was the test, because of course SC hadn't come out then, and Lord Reed's judgment of SC at paragraphs 112 and 113 were not available. And that nuanced exercise, we say, is also one which had to be carried out mindful of the role that capacity plays in the status and in the discrimination.
But we can do that, can't we? Now? Why does it need to go back to the tribunals?
Again, we say that the judge didn't make sufficient findings on the impact of those aspects of the tasks and functions being carried out by MG which were related to capacity. That looking at the functions as a whole and making findings about the relationship between capacity and the necessity for those functions to be carried out, why they were significant, why the loss of them was discriminatory, why the difference in treatment was discriminatory.
I'm sorry. Like my lady, if I've understood her correctly, it seems to me to be a matter for submission.
Yes.
This isn't a matter for finding of facts. It's a question of evaluation. We now know what the correct test is. It's as set out in SC. So why can't we, with the benefit of that learning, apply that to the facts which are set out, as my lady says, in the judgment of the upper tribunal? And then we come to a judgment, whether you're right or wrong, whether the rule can survive scrutiny under Article 14 or not.
The court has my submission on whether or not the matter should be sent back for further findings, further consideration of the evidence material to capacity, the capacity aspect of the case. We say it should, but in the event that the court's not with me, I make the following submissions on justification.
Thank you.
We say that the burden of proving justification is on the respondent. Authority for that, if needed, isn't in the bundle. I don't understand.
It's trite law.
Yes, thank you. Second point I make is that it's not the scheme as a whole, that's to say the measure as a whole, which must be justified, but its discriminatory effect. And for that we turn up AL Serbia if we need to. It's paragraph 38, Lady Hale. Does the court require me to turn it up? It's AL Serbia. Tab 16 of the bundle. Um, 1448 internal pagination, paragraph 38.
Yes, it really goes back to paragraph 68 of the Belmarsh case, where Lord Bingham first said this.
That's right, it's A, yes, indeed. And third point I make here is that this is a strict scrutiny case. In regard to Lord Reed, I've already taken the court to it, paragraphs 112 and 113. We say that this is a disability-related case involving capacity of the most vulnerable members of society, and it's a strict scrutiny type case. We
It's
accept.
also a legislation case, so the two sort of work in opposite directions. It's like Salvato.
Well, it's a subordinate legislation case.
Yeah.
So not quite like Salvato, but agreed, one in which tension between the Secretary of State having a wide margin of appreciation and the strict scrutiny, both are in play.
And it might be said the most significant feature of this is that this is about requiring the state to spend money. Belmarsh, for example, is about locking up people without trial and without charge. And there's one approach the Belmarsh case illustrates the vigour with which the House of Lords was prepared to intervene with a judgment of, even of Parliament in that case, because they made a declaration of incompatibility about primary legislation. Even in the context of national security, that's a very good illustration of how the power of review under Article 14 can be very intensive indeed, in the right context.
Yes.
But here we're dealing with an argument that the state should spend money. And it might be said that different considerations come into play.
We are also dealing with, on the appellant's case, the most vulnerable of vulnerable individuals who, in order to access treatment on something approaching the same basis as somebody who does not lack capacity, requires, and the law provides that he should have, somebody whose job it is to have that function, the function of a personal welfare deputy. And the consequence of the application of the rule to him is that he is affected because the money that would go to pay for all the things that the personal welfare deputy is doing to promote and protect his welfare in accordance with the principles of the Mental Capacity Act and broadly government policy in respect of people with disabilities, are at risk. It has a disproportionate effect on him, and that is also a very weighty matter in my respectful submission.
Yes.
So then we come to the conventional Bankman-Act four-stage test of proportionality.
Before you get to that,
Yes.
would you also accept or not that it may be relevant that even on your argument, this is not a case of direct discrimination, but a case of indirect discrimination?
We put it in the skeleton argument on the basis of either indirect or thelimenos.
I understand, but it's not direct discrimination. No. Again, you see, I draw the contrast.
The rule is neutral in its terms.
Yeah, I draw the contrast with Belmarsh.
Yes.
We're going to lock up people with after 9/11. We're going to lock up people without charge, but only if they're foreigners. So it's direct discrimination on grounds of nationality. Would you accept that, at least in principle, that invites a higher form of judicial scrutiny than indirect or thelimenos type discrimination?
Not as a matter of principle, and I think that's not the approach taken by the Supreme Court in Steinfeld and Kaiden.
No.
So we would say that the approach is as in Steinfeld and Kaiden,
Right.
if it's indirect discrimination, which in that case it was. So then we come to the four-stage
Proportionality.
test, yes. So obviously I accept that the rule itself in this case has a legitimate aim. I don't dispute that. The question is whether there's a...
Sorry, what's the legitimate aim that you accept?
It's to avoid duplication of expenditure from public funds.
All right.
Even I accept that a bright line rule can also have its own inherent legitimacy. Don't demur from that as a general proposition. However, we say for the reasons set out in our written case, which we adopt, we don't demur from it. In this case, the legitimate aim, there is no clear nexus between the legitimate aim and the measure applied to this person, the discriminatory effect. And that's because we say that the functions and the care, attention, supervision which is being provided by the personal welfare deputy isn't a duplication.
Is one way of addressing that question, going back to something you said to me earlier this morning, that at least part of the DLA component, when payable in the community, could be used to fund these sorts of activities by the deputy. So, for example, if the care is being provided by somebody else and she has to advocate or act as an intermediary, etc., that part of the DLA can be used for those functions.
There's no restrictions on what the DLA can be used.
No, I understand that, but that's why I'm saying that those expenses, let's say they are incurred,
Yes.
they can in principle be paid for by this part of the DLA, whereas what you're saying is exactly the same costs may be being incurred when somebody's in hospital,
Yes.
or perhaps even enhanced costs actually,
Yes.
because they're in hospital,
Yes.
and yet the DLA component that we're talking about is removed,
Yes.
and you say that that illustrates that there isn't a rational nexus between the legitimate aim of avoiding duplication.
That's exactly what we say.
Right.
I think we say that in terms in our skeleton argument. The other point I would make is that as well as that sort of nexus point, we would say that the discriminatory effect doesn't reflect a fair balance. And the reason why it doesn't reflect a fair balance is because the impact on MOC is so very great.
Well, I'm afraid we can't say whether the rule in the legislation
No,
is sustainable or not by the reference to the facts of one case.
that's right. But as an incapacitated person, for the reasons of his status, a person with the status of MOC rather than...
I presume that one of the uses to which somebody might put DLA would be to buy in care. That must be something that the money could be used for, respite for the carer who was at home.
Indeed.
That would be a very proper use of DLA money. So, to illustrate my Lord's point, as it were, so there you would find that would not be a burden while the person was elsewhere, you wouldn't have to pay for that substitute care if it was being provided around the clock elsewhere.
That's right, but
So we're not just thinking about trips into the community. We're thinking about how, in all circumstances, the DLA money might be paid. And it would seem to be, at least to me, to be a consequence of the fact that there is so much discretion in how the money can be spent, that the burden of hospitalisation might fall differently on people who are all within the same cohort. That the consequences of hospitalisation for severely disabled incapacitous person A and severely disabled incapacitous person B might be quite different depending upon where they lived, how the DLA money was being spent, and doesn't that cause difficulty for your argument? Because you're not, in those circumstances, I mean, the rule has got to cut across everybody, not according to how they choose to spend their DLA.
No, my lord, I don't have to show that everyone in the cohort on an indirect discrimination case.
No, but you have
is
to show that the
affected.
rule is unjustified.
Yes, and that's because it bites particularly hard on a person who lacks capacity because they haven't.
No, it wouldn't.
You say it does.
It might. Well, it depends upon how you were spending the money.
Well, the welfare deputy, personal welfare deputy, is required to account for, and she's the appointee also.
The personal welfare deputy, I would have thought, in a very large number of cases, doesn't even live with the individual for whom they are deputising. It's an entirely different animal.
We say that it's different treatment. That there's a differential impact, adverse impact on people who lack capacity because they require another person to provide the services that MG provides.
Right, understand that. So we're back to
Yeah.
the central. That's the
my
central
case
point.
in a nutshell.
Yes.
And the court's either with me.
Well, I'm sorry. That gets you through to the gateway. That gets you through the gateway to the need for justification. So there is, on the face of it, indirect discrimination
Yes.
on a relevant ground. Let's assume that we've got there, right? Now we're in the territory of seeing whether bank merit proportionality is satisfied or not.
Yes.
And you can't just say, well, I win because I can show there's a disproportionate impact.
I don't say that, and if
All right.
I gave that impression, I do apologise.
No, that's right. I just want to be clear. So why isn't there a fair balance struck here? Because, as my lord says, the legislation has got to cater for a wide variety of situations. It's not tailored. I mean, with great respect to MOC and MG, and of course, at a human level, one has enormous admiration, as my lord has said. But we can't judge the compatibility with the law of legislation by reference to any particular case. So what if the facts are that, in fact, somebody's not living with their relative for whom they're a deputy? They're not spending the money on anything to do with the need for care or communication or anything of that sort. Would your submission then lead to the proposition that the state would have to engage in a factual investigation of each individual case and make an individualized decision on whether they're to have the DLA component or not?
No. Obviously, I just want to reiterate that we don't get to the fair balance if I'm right on nexus. Because
No, I understand that.
No, we say that it's not a fair balance because the consequence for a person with the status of MOC is that the money that would be spent by the deputy on enhancing their life in whatever way the deputy thought best for them is equally needed in the context of hospital, may in fact have greater demands placed on it, and therefore that is something which the fair balance is in recognising that cohort, with their additional vulnerability caused by their capacity, the fair consequence is that there may be some individuals who, for whom the rule might not bite so harshly, but the fact that it does, demonstrably, for persons like MOC, is sufficient to...
Well, that submission would lead to saying that if there was one case where it bit harshly, that the regulation would be unlawful, which can't be right, obviously.
There will be, I think the court recognised earlier, a range of cases
Yes.
where that...
But at the moment, there simply wasn't the evidence in this case,
No.
as the judge pointed out in contradistinction to Mathieson, of a systemic fault with this. Because, I mean, as we've seen, we've been throwing backwards and forwards
Yes.
instances where you can have winners and losers, which is somewhat the consequence of bright line rules in areas involving
exactly.
enormous numbers of people. And at the moment, I think we're with this submission, we're scrutinising the point that you make about whether you're really just talking about your client as having, on the face of it, been a loser from this rule, but also turning our minds to situations where people might actually have been spared expense as a result of hospitalisation.
In my respectful submission, it follows that if the government determines, as they have, that disabled people are entitled to a care component which can be used in any way to enhance their life or to facilitate their living, and if the need for that component is not wiped out, we say, in the case of an incapacitated person by the fact of being in hospital, then it must be unfair for the rule not to recognise that unfairness and make exception for it.
But that must be fact specific, because in some cases it will be wiped out and in other cases it won't.
Well, the money can be spent anyhow.
Yes.
Right.
It means that for somebody in hospital, they don't get the money spent on them to enhance their life.
Well, that's true of anybody who'd get DLA.
But the point is that this is a person who's the ability to have their life enhanced means, because they lack capacity, having somebody who is able to fulfil that function for them. That's the material difference.
I think you've made that point very effectively, as far as I'm concerned. Now, as we're approaching what in the jargon is referred to as a convenient time, can I just check with you? Have we got your argument?
I think so. May I just turn my back from?
Of course.
Yes, those are my submissions.
Thank you very much indeed, Miss Weston. All right, well, we'll take a break at this
My lord,
point.
before we
Yes,
can I just check with Miss Weston? Does that mean, given what she said, that she's
well, I think
abandoned ground 2 and ground 3?
I think rather than us having this conversation in court, why don't you ask Miss Weston, and if she needs to clarify something afterwards, then she can do that. All right. We'll start again at because there'll be some disruption. We'll start again at 2:05.